Thank you.
I call Ron Mark.
I rise on behalf of New Zealand First, firstly to signal that New Zealand First will, as advised by our spokesperson on justice, Dennis O'Rourke, continue to support this legislation through the House. Not being the justice spokesperson and not having sat on the select committee, I am at a tad of a disadvantage in speaking to this bill, but I shall do my best, guided by Mr O'Rourke's notes. Sir, we note that in the first reading on the 2nd of July 2015, New Zealand First acknowledged that the bill was designed to give further strength to the 2006 Evidence Act through the review conducted by the Law Commission in 2013, which the Attorney General spoke of. A review which Mr O'Rourke supported on behalf of New Zealand First. We acknowledge that the bill contains some amendments that were considered technical in nature but still important, and that there were changes requested. Looking at what Mr O'Rourke and New Zealand First have said on the first reading, we spoke then about the changes to the laws on hearsay evidence. Pointed out that generally that hearsay evidence is not admissible. The Principal Act made hearsay evidence admissible in some cases, but it preserved the common law rules relating to statements of conspirators and persons involved in joint criminal enterprises. We went on to speak about the bill altering the law regarding improperly obtained evidence in criminal proceedings, and the long-standing principle that such evidence would be inadmissible. But sections 31 and 32 of the Principal Act provided that if evidence may have been improperly obtained, the judge must consider it on the balance of probabilities and decide whether or not the exclusion of the evidence is proportionate to the impropriety. There were other matters that were discussed in the first reading, relating to the admissibility of previous statements and documents used to refresh memories, mainly contained section 35(1) of the Principal Act, and previous statements of witnesses as not admissible unless absolutely necessary to respond to the challenge to the witness's veracity or accuracy in the statements provided to the court with information that the witness is unable to recall. There was mention about the issues around clauses 13, 14 of the bill, section 37 of the Principal Act, provided that parties may not offer evidence about a person's veracity unless the evidence is substantially helpful. Then issues around section 44(1) and further there on sections 57, clause 22, clause 2A. In the second reading, I noticed that New Zealand First did talk about the improvements around hearsay evidence. The second improvement in clause 30, which dealt with, which amended section 106 to the need to prevent the misuse of video records, something that's been spoken at length here in this debate this afternoon in the third reading, and pointed out that the Justice and Electoral Committee had made some important improvements to clarify the Act in this respect. There have been two of them. First one, amending section 106 to clearly specify the duties and restrictions relating to those video recordings, records that parties and lawyers have access to. And second, going on to talk about, in addition to that, in relation to that matter, the committee recommended that it was important that regulations should be made and that there should be provision to make those regulations to cover the various ways in which all of that would operate. The third improvement New Zealand First spoke about and which we focused on was the difficult area of children giving evidence, and it was pointed out this actually means people under the age of 18, something that the previous speakers just referred to again. And pointed out by New Zealand First that at the age of 18, these witnesses, these people, are not necessarily infantile. Some of them may have been able to give evidence in the ordinary way, and others not so. But the Act improved the situation in that respect. There were changes, we noted there were changes to access to video records of evidence outside the criminal and family court cases, which we agreed with. Recommendations were made and adopted by the Justice and Electoral Committee to ensure a clear and broadly uniform regulatory approach to prevent the misuse of those records by making amendments to Clause 33A, 119A, 119B. Generally speaking, getting to the select committee, to the committee stage, to the Committee of the Whole House, one of the things I will point out is that we, New Zealand First, did support Jan Logie's SOP 195 because we thought that it added strength to the bill, and like the Green Party have just expressed, we're a little bit disappointed that that SOP was rejected by the government. Mr. Speaker, New Zealand First signalled it would support this legislation at the first reading. Work constructively to have, along with the other members of the committee, to make constructive changes to that legislation, which the government accepted. And at this point on the third reading, we will signal that we intend to support the bill.